law. There was some change that will change again. One topic which I thought I can say the dilemmas of arbitrators while writing awards and dilemmas of judges while reviewing any award under Section 34 of arbitration. We have Section 28 in Arbitration and Conciliation Act. It's not that I'm confining my speech to only Indian Arbitration Act. It has what else. This Section 28 of Arbitration Act is basically parliamentary with Article 28 of the System Model Law. If one sees Section 28 of Arbitration Act, it says that arbitrators will decide the disputes by referring to substantive law of the country. It also says, if parties have otherwise agreed, arbitrators can give you decisions, resolve the disputes, ex equo ad bono, or amiable competitor. To make sense, fundamentally having identical connotations. If we try to understand it simply, how it is being viewed, it would be, can arbitrators decide the disputes by applying the principles of equity and justice? Section 28 of Arbitration and Conciliation Act says arbitrators will apply substantive law of the country. However, parties can agree otherwise and confer jurisdiction on the arbitrators to decide disputes ex equo ad bono or as an amiable competitor, meaning thereby they can decide by applying the principles of equity and justice. Now question, and I'll give you a very simple example. I'm contrasting with I'm doing this matter in the High Court. One arbitrator was deciding one family dispute of a big business house. Essentially, the nature of dispute was interpretation of a terms of a family settlement and implementation there. One of the terms of the family settlement was that the mother will get 50% of the profits of the business every year. While deciding the disputes, arbitrator says, yes, there is a clause favoring this particular amount, favoring the mother, she should get 50% of dispute, 50% of the total. However, considering the nature of the dispute between the parties, I am exercising my discretion in favor of awarding a lump sum amount of rupees 5 crores in favor of the mother. If we see this award, one can say that it is in conflict with the provisions of Section 28, which says that awards should conform to the requirements of the contract between the parties, and it should also conform to the substantive law of the country. One way to look at this award would be, you are supposed to follow the contractual terms which says mother should get 50% of the profit. Now other side, the counsels representing the mother have challenged her. He says, I was entitled to get 50% of the profit. Arbitrator has awarded something else, it is not 50%. Therefore, this violates, this offends the provisions of Section 28 of Arbitration and Conciliation Act. Honorable Judge is in dilemma. Therefore, question would be, what is this concept? How much is this relevant in our context? whether it is being really used. In fact, we had identical provision of ex equo ad bono in Article 38 of Statute of ICJ, International Court of Justice. We saw hundreds and hundreds of years law, we have seen hundreds of years. It has never been applied. 19th century, we had two situations, two cases. Countries went, they said, one country offered to go by this, other country said sorry. In recent past, we had one dispute of Bolivia, again it was offered, other side said no. We have one or two examples throughout world where both the sides really agreed to go by this principle of ex equo ad bono. Question is, should we still continue with this principle, which is generally not understood in its right perspective? Question therefore would be, why people are averse to go by this particular principle of ex equo ad bono or amiable competitor, when arbitration as a concept is a consensual arrangement where parties agree to get their disputes resolved through a process of private adjudication by a private judge. Why should it happen that even if I agree to have a particular person A as an arbitrator, why should I say he should not be allowed to go by these principles of amiable competitor? If you try to understand, the approach is an understanding widely understood concept. People generally understand the moment we will confer jurisdiction on the arbitrators to decide by referring to equity and justice alone, they may legislate. They may alter the applicable strict legal principles. I'm sorry, this is not the correct appreciation of the concept. We cannot think of an arbitration proceeding, we cannot think of an arbitration until unless we really confer some discretion on the arbitrators. We cannot have an arbitration without a discretion, some amount of discretion left with the arbitrator. Even if an arbitrator has to decide a particular dispute before him by referring to certain provisions of Indian Contract Act, still, let us take an example. Arbitrator has to decide the quantum of damages. How will he decide? Unless you confer some discretion on the arbitrator to really go into that, you will have some bit of discretion left with the arbitrators. Therefore, the argument that arbitrators have to decide, arbitrators don't have discretion, it is not the correct understanding of the arbitration as a concept in arbitration law. Question is, and how we can get rid of this whole concept which says that the moment we talk about amiable competitor, arbitrators will be going beyond the principles of law. Question here is simple. Till the time arbitrators are deciding the disputes without altering the legal provisions, without altering the substantive provisions of law, till the time arbitrator is well within his jurisdiction, and it cannot be said that he has exercised his discretion in such a manner that award is liable to be set aside. He has to escape. The fundamental question is, some amount of discretion has to be there, principles of equity needs to be applied. You will have in every jurisdiction, you have certain residual powers, sometimes we call it default powers with the arbitrators. Whether we write in the arbitration clause, whether we write in the arbitration act or not, certain residual powers are there with the arbitrators. They exercise them. And ultimately, going by the established principles of law of a particular system, arbitrators deciding their dispute. Why I raise this issue? This is connected with another important aspect. When we go to appoint an arbitrator, suppose we have a dispute, we need to have an arbitrator, we need to go to select an arbitrator. Question always remains in the mind of the litigants. or the parties who are in dispute, who should be the arbitrator? Because we have seen now, we have ONGC saw pipe Supreme Court judgment which says if your award is against substantive provisions of law, it is liable to be set aside. It says if it is against the contract terms of the contract, it is liable to be set aside. These are basically, it is like a guideline. People are finding it difficult. But what is happening? I am not going into the merit of ONGC saw pipe, this is not the subject of my speech today. What I say is, we have other judgments of Honorable Supreme Court, again those guidelines have been followed. But question would be, therefore, when you are in dispute, you need to have an arbitrator. What kind of arbitrator you should have? Whether you should have an arbitrator, because now every award which is being challenged in the court of law, other side will come out with ONGC saw pipe or judgments which are following ONGC saw pipe, Hindustan Dixit, things like that. Question would be, you need to be on, you have to safeguard your interests. If you want to have an arbitrator, question is whether you should prefer a lawyer or a retired judge having background of law, or you should have a non-lawyer or a technical person. That again is entirely a different subject on this. Why I am raising this issue? Because this section 28 is read whenever your award is being challenged. Nuances of law, if it is not well understood by the arbitrator, award is prone to challenge. Awards can be set aside by the courts by simply referring to ONGC saw pipe, but you have gone beyond the terms of the contract or gone beyond the terms of the substantive provisions of law. Now therefore, what is substantive provision of law is again required to be understood by the arbitrators. Therefore, question is, whenever one is going to appoint an arbitrator, if you have a technical dispute, it is really technical in nature. In fact, we have trained judges, trained lawyers. They are capable of deciding disputes as an arbitrator, even you have technical dispute. If it is a three members arbitration tribunal, you can have one or two experts, non-lawyers, but still you can have the lawyers or judges who are trained in law, because we cannot afford to have an award and again this award is being taken to the court and it is getting set aside on the ground that it is not in conformity with the substantive provisions of law, or it is not conforming with the requirements of the contract. Therefore, you need to have a lawyer, you need to have an arbitrator who really understands those propositions of law. I'm being asked to be brief. So therefore, I conclude by saying that even if whenever we are writing an arbitration agreement, whenever we are referring a particular dispute to a particular arbitration, we should be conscious of the requirements of section 28 and we should try to safeguard our interests by referring to those clauses. And thank you very much. Thank you very much for your attention.
Now we have among us Mr. Ashok Kapoor, who has sometimes knowledge in the field. We request that briefly he will say, enlighten us on the international commercial arbitration.
Thank you. I'm here almost in an extempore capacity to be transformed from a participant to a speaker when I was aghast at seeing my nameplate. But I'll share with you some of the thoughts as a practicing arbitrator, not a judge, but a former civil servant. I'll take off from where Mr. R.K. Singh, my predecessor, has said that should arbitration be based on equity or provisions of law? This question was answered by Aristotle, the famous Greek philosopher, who said